I'm Todd Smith, and this is your appellate tip of the week. This week's tip is think twice before moving for appellate sanctions. We've all been in a situation where we think that a pleading or a brief filed by the opposing party is taking frivolous positions, and maybe even they're misciting the record or misrepresenting case law or what the record says. I've been around long enough to have seen this over and over again in my practice, and it is inevitably very, very frustrating. So the question is, when you're discussing this issue with your client, and the client says, well, can't we do something about that? Can't we move for sanctions? Well, sure, you could, but what are the factors that go into making that decision? Well, one is going to be the expense that the client would incur in preparing a motion for sanctions. Now, this could be more or less like another brief. You'd have to present the argument, the justification for it, and how the conduct was so egregious as to warrant sanctions from the appellate court. And the second major factor would be what's the probability of success. And I'm here to tell you that it's an unfortunate thing, but the probability of success of obtaining sanctions, even in a fairly egregious situation, is pretty low. Very low, in fact, I would say. Before you undertake to even prepare a motion for sanctions, do some research. Get on Westlaw, Lexis, whatever the platform is that you use, and I'll challenge you to find any award of appellate sanctions in a case of any significance in the last 10 years, maybe more. So what I will tell you, having looked at this issue myself, is that there's only a handful of cases, and even those deal with just extremely egregious circumstances. I've seen it in my own cases where I think in 20 plus years of doing this, I've moved for sanctions one time on appeal, and it was, in my view at the time, a pretty egregious situation. The lawyer on the other side was misrepresenting the record, did not present a complete record to the Court of Appeals, and then relied on the absence of documents in the record to support what I thought was a frivolous argument. We had no choice in that case but to go ahead and pursue sanctions because we felt like it was egregious enough to do so. Unfortunately, even under those circumstances where it was pretty plain that the other side was being dishonest and trying to manipulate the appellate court, that sanctions were not awarded. So consider, I say think twice, consider what the possible benefit to your client might be, how much more an attorney's fees your client's going to have to spend to prepare a motion to properly present the argument to the appellate court, and then the probability of success. And there are going to be instances in which it's still going to be something that has to be pursued. The principle of the thing is okay as long as the client understands the risks and the likely or the likelihood, I should say, that sanctions will not be awarded even in circumstances where they should be. Our appellate courts just aren't inclined to grant sanctions, even in some pretty bad situations, because the lawyers and the clients who are the subject of these motions are generally given the benefit of a doubt, and it's just not a function that the courts of appeals tend to want to fulfill. That's it for this week's tip. We'll see you next time.